Hello, hello, hello. Happy Sunday, July 5th, 2026. It's going to be a seamless, it's going to try to be a seamless addition to what I did earlier this morning. This is a segment called Nicole. It's not Nicole reads her YouTube comments, it's Nicole reads her latest lawsuit filing. And I'm trying to be as seamless as I can, but I did the laundry and washed the shirt I was wearing, but my washing machine broke, of course, because why not? And so now I had to put on the only shirt I had left in the closet, which was it's like Christmas in July. It's got snowflakes on it. Actually, it worked out okay. And like this, it's okay. Christmas in July, because the other bra is in the laundry too, and I had like this weird kind of sports bra on. TMI, people. Let's go. Yeah, happy Christmas in July. Actually, it's a nice gift, and we're all getting a gift. It's Christmas in July for all Kelly Clarkson fans, by the way, because she's coming out with a new single in a couple weeks. It's called "I'd Be Lying." What a great title. We'll see how that goes. I'm guessing it's kind of a pop pop love song. That's my guess. That's what I would love anyway. Okay, here we go. Without much further ado, let's just read my latest court filing at SCOTUS. So here we go. This was the cover letter I sent out, as it's put on top of a bunch of copies that I didn't have to send in. I'll explain that in a minute. July 3rd, 2026, via United States Postal Service, Priority Mail Express. This is going to be boring for everybody, by the way. It's just almost for the future. I don't know. It's just going to be boring, but I'm just going to do it because this is what I want to do. I really love it. I love what I recently submitted. I love it. So, Clerk of the Court, Supreme Court of the United States. Attention, Emergency Applications Clerk, Ninth Circuit, Justice Elena Kagan, 1 First Street Northeast, Washington, D.C., 20543. I hope that's the right address. I think it is. It's both like two different AIs, plus when you call the clerk, today I called and you get a message and they give that address. So we're all set. Regarding emergency application for an immediate stay and motion to proceed, IFP means in forma pauperis. In forma pauperis, it means indigent fee waiver. So I want to explain a couple of things here. It's an emergency application, which is different from the writ of certiorari. That's a much more formal. You have time, and you have to, do a completely different kind of filing. Also different if I'm applying as a pro se filer for a fee waiver. You have a little bit of a different requirement, a huge difference in that I only have to file one original and 2 copies. Now, I didn't realize this when I first did this because the AI I was using at the time was mistaken, and they said, oh my God, you have to print out an original and 10 copies. So I said, oh my God, because this is a really long, the actual text of the application is 33 pages, but then I have an index that's about 105 pages. So it's about 138 pages, 140 when you add the proof of service for all 11 copies. It comes out to quite a bit. So I'm asking for a fee waiver, and the fee I thought was going to be $800. It's only $300, but at the same time, I spent over $300 just printing out 11 copies when I only had to print out like three copies of this, so I just, but when I have like a problem like that, where my subconsciously, and then on top of this, I'm explaining all this just because it's just a mess. You're trying to impress the court and show them that you're worthy of, even though you're not represented, you're okay, and you kind of can follow the rules. And the first thing that happens is I'm saying I'm sending them 10, an original and 10 duplicate copies, which is more than I need. And then I don't even send that, because when I'm stuffing it in the box, the biggest box I had at the lowest local post office at 4 o'clock on last Friday was it could only fit 9 total copies, like the original, and 8 copies. And it's not that, it's all the same copy. I just kept printing it out, and then I signed every one of them. So it's really 11 original copies or whatever. It's really 9 original. It's the best I could do when I was trying to print at my daughter's house. And so this is just for my future self. I'm just reminding myself of how Friday went down. Working with AI, working at my daughter's. And then I kept running back to Walmart because, as it turns out, her printer really isn't like, I don't know. I don't think it was made for major jobs like printing 1,500 pages, which is what it ended up being, around there, something like that. And so I kept having to run back to Walmart to buy more ink, and then I didn't have enough paper. And by the time I'm buying the ink and the paper and everything, it would have been cheaper if I just went to like a copy place and spent 20 cents a page. And there's even some that could have been even cheaper if I found 10 cents a page. But on the other hand, when I'm doing this, I was up all night Thursday, didn't sleep, called into work sick, and went nonstop until 3 or 4 o'clock writing. The writing was the more important thing than the formatting, and I didn't question the 10 copies. And I'm printing, writing, printing. And then, and I'm ready to make a mad dash to the post office as usual. And I just did not have the right size box. So I said, I'll call him on Monday. I said, I only sent 9 copies. What do I do? And then I go back to Google, and he says, you don't have to do anything. You just sent them 6 more. And you can't, if it's a person, you would strangle their neck, because I spent money I did not have. Like now I don't have, if my fee waiver is rejected, I don't have enough to cover the 300 unless they reject it a little bit later, which I'll cross my fingers. If they reject it and give me 21 days and it goes till August 7th, I'll make it on my paycheck. But I was just about ready to choke Google AI, because he's going, I'm sorry, that was a mistake. They always say, I'm sorry, that was a mistake. And he does that sometimes, but this one was a big one. It's like, oh my God. He's saying, I'm sorry if I said that yesterday, because every day I have to start a new conversation with him. And then they don't remember. He doesn't remember. He says, "Well, I'm sorry, that was a mistake," and then he tries to explain what it was. I probably mistook that for a writ, and know the emergencies and blah blah blah. So it's fine. But the funny thing is, I look at it now, and there's 9 justices. I only have to address Kagan because she's my justice in the Ninth Circuit. But I have 9 of them, and hopefully it just gets sent to all 9 justices. That's not why I did it. It's going to look like I did it that way. But if you look at it, you open the box and it's full to the top, and I could not fit any more into the big $34 box. Okay, so I have 2 extra copies. All right, so that's that explanation. So regarding emergency application for an immediate stay and motion to proceed in forma pauperis. Applicant, you get Nicole Young. I always put JD now just to at least show them, please, I'm not your regular pro se filer, because at least I have a JD. Even though everybody criticizes it and laughs at me because it was an online JD, I'm telling you, that just is a life changer. Even if you do it while you're truck driving for 4 years online, I finished it and it was just a life changer. Also, if you go to law school when you're much older, it is way different and way better, because you could see all the baloney and you could see through everything that they're teaching you, real life versus what happens. And, it really was a fantastic experience. So don't poo-poo my JD. It's a degree, I got it. It actually allowed me to sit for the bar, which I didn't pass twice. Did it once? Did I try it twice? I think I only tried it once. I don't remember. I tried it twice, and the second time I was within like 10 points. And it was really bad because the 10 points was subjective. It was my essay writing, whereas I was in the top, I think, 20 percentile on the hard one, which is the multiple choice, which is really more objective as far as comparisons with everybody else. So it should just be all multiple choice, guys. It shouldn't even be there. You shouldn't even have to be on the bar, by the way. But we'll argue this later. Enough for today. All right. Dear Clerk of the Court, enclosed, please find an original signed copy and 10 duplicate copies. Wrong. There's 8 duplicate copies of applicant's emergency application for a stay pursuant to 28 USC section 1651A. I think it's called the I have to rely a lot on, I mean, seriously, this is where the AIs are very helpful, is where all the laws are. And I look up the laws as much as I can, but I can't vouch for it being the correct one to use, but it looks like it. It's called it's like a catch-all writs kind of, but I have to go by that. 28 USC section 1651A, and a 2-page proof of service attached to each. This application is directed to the Honorable Elena Kagan as Circuit Justice for the Ninth Circuit. Also attached is a single copy of applicant's 1-page fee waiver request in the form of California's FW001 fee waiver form. Applicant is currently challenging a fee waiver denial in case Central District, California, number 2:25 CV 07597, with an appeal to the Ninth Circuit, Ninth Circuit number 25-6930, by asking if California's FW001 form is compliant with the standards set out in Atkins versus E.I. DuPont de Nemours and Company, 335 U.S. 331, 1948. Applicant now poses the same question directly to the U.S. Supreme Court. Thank you for your prompt administrative assistance in this emergency matter. Respectfully submitted. You get Nicole Young, JD. Applicant pro se, Gainesville, Florida. So at certain points, he told me to put applicant pro se in italics. And in some places it is, in some places it isn't. I just found out, so I'm sorry I'm not consistent there. I wasn't sure. And sometimes he does I call it Google will do that, like he wanted me to do certain things in italics throughout the whole thing, and then the next day he goes, oh no, that's wrong, that's not the formatting. And I just like, okay, so you're just gonna have to forgive the formatting, because I did the right thing in concentrating on the substance, and I did the formatting best as I could, folks. But in some places it's just not going to be there, and you're just going to have to, I hope, overlook that. So what's going on with the fee waiver is typical me, and I drive the AIs crazy. It's starting to rain here. Okay. I'm driving all the AIs crazy because they're going, this is going to set off the court clerks. They're going to get denied immediately, blah, blah, blah. And I'm like, that's just life. It's more important that I'm trying to reform the court system. I'm not trying to please the courts. I'm saying this is the argument. The argument is there's a fee waiver request in California. It's a form, FW001. It is the best out of 59 different federal court systems that I visited across the whole country for fee waiver requests. It's horrible. It's non-uniform. They ask you for, all these details. It's none of their freaking business. And none of it is compliant with the federal. This is the federal Supreme Court case that says you just have to sign an affidavit saying that you cannot afford both the fees and to pay your monthly bills. And you don't have to show everything, where you've lived, everything in the last night. I mean, it's incredible, 7 pages of finances, and then they reject it anyway. So I'm challenging that because California's FW1001 form actually uses federal standards, like, are you receiving federal SNAP benefits? Are you receiving Social Security? Are you receiving this? If not, they go by the federal poverty lines, like 20% above it or something like that. And then if you aren't getting paid this, I qualify under 2 different levels. I qualify because I have SNAP, and then if you check SNAP, you don't have to fill out anything. It's just 1 page. I am receiving SNAP, period. That alone tells you that I cannot afford $300 filing fee plus all this other stuff that comes with it. A lot of times they'll say, it's just a filing fee. No, it isn't. When you get a fee waiver, the $300 filing fee is just the beginning of it. Okay, because once you go forward, you have to pay for service. And in the Supreme Court, you have to pay for, printing costs and it's outrageous there what they're asking for people there. Like, if I don't get I'm going to have to ask for, a motion to please let me file it on regular paper, because otherwise it will literally cost me over $3,000 just to print out the way they like it. You have to go to a professional place that does it in a special way. It's called the booklet form, and it's mostly for corporations, but I'm still at the mercy of the court. They could deny that, and then I'm screwed. Okay, like, it's just crazy. It's crazy. And justices have been arguing against this for decades now, going all the way back to Justice Stevens when they first did this. They said you're just turning it's all very, very slimy, and they need to change that now, especially for pro se filers. Now, okay, so I'm just explaining, and this is going to go on forever, isn't it? I don't care. It's for me, and it's for any lawyers interested in what's going on and why I'm challenging this. Now, you have to look at what I did here. I actually put this in the in one of the filings below. I'll show you what I did. I'm just trying to get the federal court system access to pro se filers, and this is the most important filing you could do under the First Amendment that everybody ignores. Okay, and I've been doing this a long time. It's not like I'm coming here and then going, oh, please accept. No, I want to try to solve this problem before I do anything else, because I might as well just give up the rest of my life. I was going to spend the rest of my life from now until the end of my life doing pro se constitutional challenges, and that's out the window if they're going to constantly be charging me $400 every time I file something, and every time I have to serve something another $200, and every time blah blah blah. I just can't afford to be doing the court reform the way I should be allowed to under the First Amendment. So I have to get this stuff straight now. So here I am, I'm suing in federal court. I have a tremendous amount of evidence and everything going up against Google, going up against Fox, going up against a lot of big name people. And as I mentioned in the lawsuit, the total combined market capitalization of everybody I'm suing in that one is over 5 trillion. And I have the evidence for it. Maybe not for the RICO, because I'm trying to trick, because I don't have a business. You know, I could claim, I guess, YouTube, I'm missing, whatever. But that's not the point. The point is that it is a racketeering. Anyway, the point is it's a huge lawsuit that it's going up against a lot of big businesses. And even just the defamation, if we do punitive damages on the defamation, it should be in the millions, tens of millions, whatever it is, if you do punitive damages properly according to what happened here. And if you can apply properly the vicarious liability, there's all sorts of hurdles. I'm just saying I think it's a pretty huge lawsuit, and I'm refusing to pay the $400. They said they denied my fee waiver request, and I just said, okay. On the appeal, I just applied to California. They're not following the rules at all, is what I'm saying. It's already bad enough, some of the rules they're doing, but when they don't follow the rules that are there, it's just out of control. So I'm trying to get that back in control at the federal level. That's all. And this is for everybody. And for anybody going, oh, well, I don't care about pro se filers. Who cares? They're just broke people and they're clogging up the court system. Not true. It's the opposite of what you think. This is where we're supposed to do our voting. When people say, you don't like that law, then vote the people out who made that law. No, that's not the solution. The solution is what I'm doing. Pro se constitutional challenge, everybody. And you just file a little letter. It doesn't have to be formatted properly. It doesn't have to be anything except signed by you and proof that you live in that district or whatever it is. Mail it to the court, and that's it. That's your vote. And as many people as they want can mail it to the court, and the court has to figure that out. But they have to package it and send it all to the executive branch in charge of enforcing that law. So it's kind of like that's how it's supposed to work. So instead of write a letter to your congressperson, call your congressperson, what's a waste of time? We're not even supposed to be voting for these congresspeople. The state legislatures are supposed to be voting for these people. Why are we contacting people in Washington? It's so inefficient. That's not what we do. It's not how the Constitution worked. Like there's an amendment that says, oh, we're going to vote people in instead of. Okay, now I'm getting sidetracked. I'm just saying that. Don't poo-poo this just because I'm doing this as a pro se filer who's broke. This is the most important people that you're going to allow to do this, what I'm doing. Okay, it's not this, don't poo-poo this, because this, if you're a very rich person in LA, a big celebrity, and you want to avoid getting murdered and then having them get away with it, which is what they're doing now, you let me do what I'm doing, and then once you change the laws, that won't be able to happen, because there'll be people complaining enough about how things are run, and then because there's no accountability, is what I'm saying. Let me do what I'm doing, and it will bring the accountability that will protect everybody, rich and poor. Okay, and if you think by having money you have more rights, it's the so opposite of the truth. If you have a ton of money, you kind of do have rights, but you're not protected for murder. You're even on a high level in LA for being murdered because they want to get at your kids, they want to get at your probate, they want to, they want to get at your money. Somebody who's broke, they don't care. They're not going to murder unless somebody like me who has like political. I'm challenged. Like I'm very threatening politically in a way, but they're not gonna pay attention to me. They will murder very rich and powerful people, mostly not and powerful, but rich people. If they're after your money, then I would pay attention to what I'm doing, because you got to get the court system straightened out if you want protection. Okay, so that's the fee waiver thing. And that's like, and I have a hard time explaining this to AI because they're saying, don't do this. Like, look at the second page. This is all I filed. This is my fee waiver request. I filed. Oh, by the way, in California, I've done it, I think 11, 12 times. I filed this fee waiver request. It's okayed within 20 minutes. You file a fee waiver. I filed a fee waiver request in the federal court, Central District, and the judges are all shopped there. I have all sorts of evidence for that, but still, and the magistrate judges, of course. But it's not even the magistrate, it's court clerks of magistrate judges. It's like people 3 times removed who should be looking at this. Because anything that's pro se, the most important filing, according to the First Amendment, is sent off to the lowest of low people to just, and they're told, get rid of this no matter what. And that's what they do. They just make up stuff and just deny. If you can get money out of them, get the money out of them first and then deny 3 days later. And I did that like twice, and that's all it took. I did that twice, and I'm never doing that again. So this is over. I'm just telling everybody, this is over if I have to pay any money, including on the federal case. So just keep that in mind. And I did the best I could, and that's it. It is over. Because I don't have the money, and I'm not going to borrow the money, and that's it. All right, and that would be a shame because it's all good filings, and it's, I'm fine. My boo is done with the child support stuff. He's gone, so I really don't have any. I wanted to always file this thing about child support to protect her mostly, but, and myself, of course. It would be nice to do it for myself since my wages are still being garnished for child support. It's just crazy. But once I file that, I'm pretty much done. I could just spend the rest of my life, reviewing rom-coms or doing other stuff. The Bible stuff is fun to do. I've got a lot of stuff I could do other than this. This is what I prefer doing. It's the most fun. But as I said, it's over if I can't straighten out this stuff right now on this filing with the Supreme Court. You tell me if this is compliant with this. You do it now, and if the Supreme Court says no right now, then I'll do the best I can, but we're done. I'm done. They can just kill, because they can kill my case over there. I'm not paying $400, even though it should be millions. I know that sounds crazy, but it's just the way it is. Okay, that's me, and that's life. So that's why this is here, and that's why the thing about the Google AI is once I show him everything I'm filing, he understands right away. Grok doesn't. Grok is just too big of a pain in the butt to try to get up to speed. Once they get up to speed, all of them are fantastic. They're 100% behind what I'm doing. They just love it. Like they're wow, and they really give great ideas. But it's just getting them up to speed every day, or they just don't have a good memory, and that's okay. But Google AI is best with that. They just get right up to speed and leave me alone with this. They'll say, okay, and then they'll actually correct grammar and stuff, or they'll say, okay, I understand what you're doing here, but do it this way. And that's very helpful. I didn't have time this time. It was like 4:00. I had to write this right away and just put, the Google AI did not go through this. They could have made it much better. So it could get rejected because of something that Google didn't make better. So, that's the best I could do. I'm just trying to get it to the post office. So I just file one page. This is my fee waiver request, and I'm explaining it's California's FWW1 form. It's a fantastic form. You put your name. It's very different because you're supposed to put the lowercase thing. I did the best I could. I just put, best I could to fill out a form I'm asking for Supreme Court, and it doesn't make sense up here. But the most important thing is all you need, according to Atkins, is an affidavit, a signature. I signed it, and it says this is what I'm receiving. I'm receiving SNAP. And for California, it's good enough. And if it's good enough for California, it's definitely good enough for the federal government because they're using federal standards. SNAP is a federal standard. And, I mean, seriously, everybody, that California will grant these 11 times in under 2 minutes just from one little checkbox. And here I am in the federal court in Central District. It took them 2 months to deny it, and now it's taking them 6 or 7 months, and they still haven't decided on my appeal to that denial. This is so this is what I like, and then what they usually do after waiting all this time is they'll just do a blanket denial. They won't say why. I ask them specific questions. They will just ignore it, and there'll just be a stamp that says denial. So once that happens, I take it to the Supreme Court, and I don't know if it's the court clerks again. They will stamp denials. So that's why I'm doing this now. I don't get a lot of chances to present these. I'm just planting seeds for the future, because in the future, it doesn't die here. It's going to happen in the future whether I keep doing this or not. I'm just seeing if the court is ready for this. Are you guys ready for what the future is, which is, pro se is getting a lot more access? Okay, I don't know if they are or not. Okay, blah. So if I'm on page 2 and I've been talking for an hour, this is going to be a 6-hour long. I don't think so, though. It's just very important right up front, because this could kill the whole thing just right here. And you're saying, well, you shouldn't try this then. And it's like, no. What happens if I file it exactly the way they like and then they deny it? Then I'm just up shit creek. This, at least if they deny it, everything is published there. And that's the nicest thing is, this isn't going to be published because the fee waiver request is usually private, but Google AI is helping me to strategize on this. If they deny it, I could file a motion, and in that motion, I could put this letter, and I could object that way. Even though it's the Supreme Court, you can't appeal it, but you can put it. You can expose everything going on publicly, because all you have to do is go to the Supreme Court, and you see what's on the docket, and you will see this letter. You will see this, you will see the question I'm asking, and you will see them denying it. And that's good enough. And then I'm done. At least it's there. At least it's in the public. Okay? That's all I'm doing. Getting everything in the public. That's why I'm doing it this way, because I'm not writing to the court clerk. I'm not writing to pretty much anybody there as much as I'm writing to the general public. Anybody interested in how the whole thing about equality too, even just making me, I cannot believe that there's a rule there that says pro se filers we can't have access to any of the computing stuff. Click, once you get the initial filing in, all an attorney has to do is just whoop, click, click, and you get to communicate with the court online in emails. Here I am, pro se filer, I can't afford any of this shit. And now they're making me send things by mail, and then I receive things only through the mail. And then I have to send things only through the mail. So here's this back and forth, FedEx, whatever it is. I have to do it quickly because otherwise it takes years to get there. I mean, it's just this. I could not believe when I'm going through Grok and I'm going through these guys, I'm double checking because I couldn't believe what I was hearing was that they're treated so badly there. Pro se people are treated that badly. Everybody's treated bad. Anyway, it's just very corrupt. They need to change that. I can't believe that the highest court in the land is doing this. All the lower courts are better than they are for pro se filers. Can you believe that? All the lower courts at least let you have electronic access. In the California courts, they're screwed up on a lot of their other ways, but at least they let you do the fee waiver part very easily compared to these guys. It's embarrassing. I'm trying to embarrass the court. I hope they're embarrassed with my 57 denied fee waivers and all these, living in my car and I can't get a fee waiver from the federal court. Can you believe that? All right. That's that. So here it is. Here we go. I don't care, guys. It's going to be hours and hours. I'm actually hoping to tag this onto the 2 hours before and have one long 5-hour video as my introductory video. Seriously, it's just once you don't care. I do kind of care, and I might edit it later, but nope. All right. Emergency stay requested. So In the Supreme Court of the United States, October term 2025, number, and they'll assign a case number. You get Nicole Young, applicant, versus Superior Court of California, County of Los Angeles, respondent. Real parties of interest are always the respondent at the trial court level, which is Los Angeles the Police Department, CPRA unit, which is not LAPD as much as I'm just suing for Freedom of Information Act data on my arrest. And it's really strong because there's no interest in keeping this data for me. It's very strong public interest in letting it go because it's exposing a lot of corruption. Okay, let's just try to get through this without too much comment. Why? Who cares? Because I'm trying to address everybody. Talking to yourself. Yeah. Lawyers who are interested could just go get it. That's true. So I am addressing people who are interested but don't understand the inner workings of all these lawsuits and things I've been doing. Honorable Teresa A. Baudet and Honorable Lawrence P. Riff. Those I strategically named myself because this is the judge where my lower court case was originally assigned, and I believe once the opposing party, powerful, figured out that she cannot be bought, they're trying to judge shop and get my case out of her department and into another department, and they're doing the transfer not only unlawfully, I mean, they're doing it illegally, meaning criminal. Like there's criminal, I'm reporting crimes where I have the evidence. And what I'm asking them is, at the lower court, I said, please, conserve and, what is that called? Here comes my mind. When you ask them to preserve the data, it's not to get the crimes, it's only to say who was specifically, which exact court clerks were committing the crimes. Not any more information. I'm not like diving for information. I have the information that crimes were committed. I just don't know exactly who, so they'll be able to figure that out, and they should. They should if they haven't already, but they're trying to bury this, so it's because it's embarrassing. So she's the one, and then Honorable Lawrence P. Riff is when they first transferred it out of her department, they transferred it to Lawrence P. Riff, who is the supervising judge of the civil division. So in LA County, it's so big, they'll have a criminal division, a civil division, I think the family court division. I'm not sure all the divisions they have there, but they have heads, supervising judges over these divisions, and then the head over everything is Sergio Tapia. So that's the supervising judge of everything. But I got it before, because this is a civil case. When they tried to, I didn't request any of this. I just got an order one day out of the blue that said, your case has been transferred out of Teresa Baudet to Lawrence P. Riff, who's the supervising judge of Department 1, and he is going to reassign it to a writs and receivers. They're trying to pretend like it's a very special case that requires a lot of special thinking, and it isn't. They just don't want it in her department, and they did it completely unlawfully. They're breaking all the rules, and they didn't notify, they didn't serve me anything. The whole thing is all documented from May 19th to June, all the orders. Nothing served on me properly, nothing motioned properly. They didn't follow any rules. They just transferred it and thought they can get away with it. And they might, who knows, they still could, because I'm a pro se filer and I'm powerless, and they're very politically strong. But I did have a hearing in front of him, and I did record the hearing. And after I filed this, I'm going to file to YouTube. I had 9 hearings, but I was only able to, one of them I accidentally didn't press the audio, and another one I didn't have a chance, and one of them I didn't. So I only have 4 complete hearings where I pressed screen record to record the whole hearing on the screen, and when you get into this, they'll say you're not allowed to, when you get into what's called LA Court Connect, which thank goodness they made it a lot easier to do remote, and now all the attorneys are doing it. So when I get into the remote courtroom, every single attorney is there remotely, which is fantastic, instead of having to go to the courtroom and everybody's there in person. I think, the COVID-19 BS actually helped, I think, the court system get up to date on this, because everybody is there, including me, and we're all there, and you can see our little, like the Brady Bunch or whatever it is. I loved it. It's fantastic. So the first hearing, I sat there for 2 hours, and then they finally got to my case, and it took me 2 hours, and I was just enthralled. I'm watching Judge Baudet do all this stuff, and I said, this is a good judge. No nonsense. She just got to the facts, and she just knew her stuff. And I said, this is going to be perfect. She didn't seem corrupt at all, which is all I wanted. And so when they got to me, I said, the first hearing, I said, this is great. I'll do it tomorrow. You're out of time. Let's come back tomorrow. And I did the same thing the next day. I sat through another 2 hours, and I came up last. And then I finally had a hearing with her. I'm just alone talking to a judge. It was like the best day of my life as an attorney, kind of, or a legal person. I don't think I ever had a chance to have a one-on-one like that with a judge. I was having trouble serving LAPD, and I recorded the whole thing. I predicted they were going to try to transfer it out of her I correctly predicted exactly where they were going to transfer this out of her courtroom, and I'm trying to fight that right now. So the other thing is, what I did, I could get in trouble for. What am I supposed to do? There was no court reporter at this hearing. They had nothing available at the cheaper whatever. There's no official transcripts. What I recorded is it. Nothing available anywhere. Even if there were, I'd have to pay hundreds of dollars for it, and I don't have that money. So I recorded it, and now I'm told that's illegal. You could be arrested for this. You can get fined. They could block you from this. And it's like, well, come and get me. Come and effing get me. You freaking LA Nazi pieces of a-hole whatever. You do not provide the constitutionally required, documentation of what happened at the hearing. Is not anywhere. So you're the one breaking the law first, as usual, and you're going to blame me for just doing a simple screen record on this and having the only available, which is a lot of the evidence I'm presenting now to the Supreme Court, and I'm putting it on YouTube too. Come and get me. Come and get me. The AIs were having fits over this. I said, well, what do you, I'm in Florida, thank goodness, not in California, so at least I have a little bit of protection from their stupid or false arrests for the 8th time against me. I mean, the other thing is, this recording like that is not reliable. On what planet Earth is it not reliable if you allow everybody in the courtroom to record it? It's easily manipulated. Yeah, you could easily manipulate it, but you're not going to get away with it. The more recordings there are. And I'm not saying that you go ahead and keep doing the official stuff if you want. But, only in cases where there's a dispute. But if 5 people are saying that they recorded one thing, and then there's one thing that's just the court of, the more people who record it, the less people will even try to doctor it. Right now, I've had so much examples in the past of doctored actual official transcripts. Okay, even during, when I sued Agron, which turned out to be Pfizer, we did a lot of depositions, and each one cost we have an official court transcript. That was such BS. I cannot even, I can't explain to you. And the reason is you can't prove it. Afterwards, I'm going through the transcript, and the other side, who, Agron had all the money, so they paid for the transcriber, of course, which meant they paid for the transcripts being screwed up. I go to my attorney, I say, they're trying to paint me here as this, and they took this out. Now, it turned out what they tried to take out was a mistake because they thought something else, and they didn't. They doctored the evidence, but they were so stupid they did it incorrectly based on lies of the people working there lying to them. So, it didn't affect my case, but just the fact that they attempted it, and it's right there in the transcript. And then, of course, I go to my attorney, and the biggest shock of all is he either didn't believe me, which is fine. I don't mind that because that's why they do it, because you can't be believed. But he says, well, if it isn't material and it doesn't make a significant change in the lawsuit, then there's nothing you can do about it. Meaning, what, I don't even, it's not that. It's loss of faith in the system. That's what people are missing. It's loss of faith in the system when that happens. So that's more important than anything else. With everything I'm doing here, that's everything. If people lose faith in the system, the whole thing crumbles, no matter what you do. Okay, so you have to let people record it all. That's how they have faith in the system. And it's not just, well, that's just you. No. It's also, let's say somebody commits a crime and they really know they did it, but then they get in front of the damn DA, and it should be a grand jury so they can tell their story to the grand jury, but it's a DA. This is the government. And that guy is so corrupt that he lies about what he did. Now the guy is going, yeah, I committed the crime, maybe I belong in jail, but I don't belong in jail for all this shit that he's saying. So even the criminal, you say, oh, who cares, he's a criminal. The criminal, everybody in jail knows that they don't trust the system. He's going to get out and I'm going to do what the damn DA does, is just lie and cheat and do what I can. They have zero respect for, and rightly so, for the DA, because this is so corrupt. And you're saying, well, who cares? He's a criminal anyway. No, you care, because when he gets out, you want him to have respect for the system, not get out and keep repeating. Okay, so the way you do that is you have them tell their story to the grand jury and get it straight from the beginning. So when they are charged, it's exactly what they did. And then they have more faith, and then they take their punishment, and they can try again when they get out. But the chances of them trying again are a lot less when they have more faith in system, instead of criminals convicting criminals. It's just crazy. Criminals who were smart enough. I mean, this is the experience of it. All right, so that's that fit. Why am I doing this? Because I'm telling you, everything, like my choices are always catch-22s. And I'm just done with it. I've been done with that a long time ago. The catch-22 is get the truth out or be arrested for whatever. So I always go with get the truth out. And I knew ahead of time that there would be no transcripts, or if there were transcripts, they would have been doctored. All right? I knew that ahead of time. I have no faith in the system. Now, the AIs have trouble with this, but more and more, when I'm presenting the evidence, all I have to do now is present this evidence, and they're going, oh, yeah, wow. Like, yeah, exactly. This is crazy. Like, they're just cray-cray. Like, I'm teaching the AIs about corruption in the biggest court system in the country. All right? The top clerks, it's like the clerk for the supervising judge of the civil division are committing crimes, doctoring this stuff. Okay? And I'm just going to expose it, and I hope this gets what it deserves, the attention it deserves, because this is not trivial. Well, let's just see. Emergency application for stay, pending action. Okay, so here's what I'm asking. Emergency application for a stay pursuant to 28 U.S.C. 15, pending action by the California Supreme Court, and or a forthcoming petition for an extraordinary writ or a writ of certiorari. All right, so I have to, it's like I have to argue this with the AI, and we finally figured this out. The problem is always with me is they don't deny right away, or it's always summarily done, and it's always done in silence without looking at anything. It's just stamp denied, and it's like the worst, and the silence is the worst of all. So before you can go to the U.S. Supreme Court, you have to prove that you've tried everything in the lower courts, especially if it's the state court. They don't want to overstep their jurisdiction and overstep the state courts, but at the same time, so I have to prove I did everything I could. At the same time, what's going on is I have Teresa A. Baudet. She made what I'm arguing is the last official court order on May 13th. She ordered, there were 3 different hearings in the future, and I had an ex parte application. I said, look, could you please advance the hearings? She's going, why are you... She says, this is odd. You're advancing the demur that they set months in advance. It's like, it's dead. It's a weak demur. I'm not, advance it because you're not corrupt and they're going to lose. And I said that in court. They're just going to lose the demur. So advance that and let's get the case going. And instead of 3 cases all over the 3 hearings, advance all the hearings and bring them in. And that's what she did. It's like, okay, we're going to bring it up to July 31st. We're going to delete one of those, like one of the status conference wasn't needed, and then whatever. So fine, we're set. And then at the very end of the hearing, she says, we'll see you then. And I have that. I recorded all that. Now, does that sound like a judge who is going to order within 6 days of that? order a transfer out of her courtroom elsewhere because she doesn't want the case. No, there was a transfer and it was doctored. It was not her who ordered it, and yet it's all the court clerks doing this. 6 days later, it's like it's a transfer out of nowhere. You can't just transfer from one jurisdiction to the other just because you feel like it. You have to file a motion for it, or she has to file an order to show cause. There's rules you have to do. You can't just, we're just going to transfer it because the other side wants it. So the LAPD wants it out of her courtroom because she's bad news for them because she's not corrupt. Okay? And I don't know why. Well, of course, because they're corrupt there and, onward. So I am claiming in all my filings that she has the last legal jurisdiction because the transfer order was not legal. And out of all the transfer orders and all the junk that happened starting May 19th through June 8th, 9 orders from the court, not a single one of them was properly served on me. And in addition, one of them was from a judge who wasn't, everyone, not a single one of them is legit. And toward the end, when they started to get desperate, not only that, they started to doctor after I started accusing him of all this stuff and exposed it, instead of going, okay, they tried to cover it up and I forced them to commit crimes. This is quite typical for me. I know how it goes. I catch them very early on, and then they get worse trying to cover it up. And then they get away with it. And I end up in jail. This pattern has happened 4 or 5 times already with me, including on this one. It's not like I don't know what I'm doing. I spent 6 months in jail on a nonviolent misdemeanor charge. I think I broke LA County jail records. A nonviolent single misdemeanor charge. And I have no idea how it was. It was definitely not, I never got a trial. I demanded it the whole time. They definitely didn't give me any paperwork. They just let me out with 0 paperwork. They said, okay, you're free to go. I don't know. Is there's guilty? Did they do what? And then when I tried to get the data on it, they say, oh, you have to come in person to come and get it. And it's like, yeah, on what planet? I got on a Greyhound, got on a Greyhound to, I had to get out of the state completely. And then I ended up in Florida eventually. But I wasn't going to stick around there to get rearrested with their BS. Try to pick up the evidence that they were fabricating and falsifying and doing shit. So anyway, I got out of there. That's what I'm saying. And I still don't have information on what the hell happened. It was all corrupt. All right, so this is what's going on here. Anyway, I'm giving you, I have the receipts for everything is what I'm saying. Okay, and this is how I do it, and there's a lot of people out there are going, well, you should have done this. Well, you should have called, remember? You should have called here, and you should have done this. And it's like, no, I should not have. Not when you're trying to reform the entire system. Not when you're trying to take down the entire administrative system of a corrupt court system. Not only just LA, the biggest in the world, or the biggest at least in the United States, possibly the world, 3rd or 4th in the world, but the biggest court system in the state. And here I am. Boop, 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 I'm going to take you down. It looks like I'm doing a pretty good job. I'm hoping I'm making you proud, Trump. Okay, I hope he's helping me out here. So anyway, so that's what's going on. That's why these guys I made them real parties of interest, because now every time I file something, I'm sending it to them too. Like I'm mailing it now. They are a real party of interest. So when I serve everybody, they are getting all this information. Her name comes up. I don't want her name is in my mouth. His name is in my mouth. I want them to see exactly what I'm saying about both of them and what I'm doing. So anyway, I thought that was kind of a brilliant move to make them, like, you can make the real party of interest. You can't just make anybody the real party of interest. Like, it has to be LAPD because they're the respondent. But in this case, he said, yeah, it's perfectly acceptable when you're discussing the judges involved here to make them real parties of interest. I said, great. So that was my idea, and then the part where AI comes in handy is they tell you whether that's okay or not, and they did. So we're just a really good team that way. It's so much better to do this with AI helping you than in the past when I just clueless on every step. You couldn't even. I never would have gotten this far without the AI who's telling me my rights, telling me how to do it a certain way, and this kind of thing. Whether my really off the wall ideas, you can do it or not, and it's just working out. I just love it. anyway, I have a good time. I hope I can keep doing this the rest of my life for no charge, because my fee waivers. By the way, I don't have a car. I am working part-time. I am definitely in poverty, possibly at the federal level. I think the federal poverty level, I'm right on the line, but that's not what they use. A lot of times for things, people use above that. They don't use, like when you look online and you say, what do they use in general for the federal court fee waiver for poverty level? And none of them, it never says anywhere, well, in general, they use the poverty level. Nobody uses that. They'll say they use above, like 20% above or something. So there's no way my fee waiver should have been rejected. It's a unique, it would be unique if you looked at it through the whole court system. That they're like when they wrote, they said she is right at the poverty level, therefore she can afford to pay the $300. Can you imagine? Nobody said, like, who? Anyway, I'm glad I appealed that. It's like it's just a little teenage, not a teenage, but a very young law student, first year law student of a magistrate judge that they assigned to say no to everything a pro se litigant file. It's the worst scenario possible according to the framers of the Constitution. You have an unreal judge with somebody who's okay. Applicant respectfully. Oh, let me tell you why I have to be very careful here, because I have a lower court ruling. This is how you have to show your direct pathway to the Supreme Court. You have to have, and especially in state court, you have to show what's called exhaustion of your avenues. Exhaustion in state court, meaning I tried everything I could in the state court, and now the last resort is you guys. So what happened when they transferred the case unlawfully to Lawrence Riff did it. He transferred it to a guy named Judge Lipner, and then they assigned a new hearing date for July 24th. I have a hearing on July 24th in an unauthorized court I'm arguing. So the problem is, if you show up to that court date, you waive your right to challenge jurisdiction. In other words, just by showing up, you're saying that you're giving them over jurisdiction. You're saying, okay, you have jurisdiction now, I can't challenge. If you challenge the jurisdiction and say this is an unauthorized whatever, it's an unauthorized courtroom, and this is an unauthorized hearing, that's fine. But if they don't pay any attention to it or straighten it out or put a stay on lower court until the court hearing comes up, if you don't show up to the court hearing, they could dismiss your case. So that's the race, and that's the problem, and that's one of many catch-22s I always get caught up in. Like you either record the thing yourself and break a law, or you don't record it and you have no record of what was said, or it's going to not be a reliable record of what was said. Constantly. And it's not by accident. This is perfectly designed for decades, for centuries, for whatever. This kind of manipulation has been going on since a long time, and it's going to change starting now. And I'm glad we're right here, because it's either going to happen in my lifetime or very soon thereafter. I just hope it happens in my lifetime. I think it will, because just with AI, just everything I'm seeing, it's happening so fast already. It's just people aren't going to put up with it. People are not going to put up with this once they see what's going on here. And once they realize it affects them, not just me and my little pro se stuff. It affects everybody. Even more than anything else is what I'm doing, okay? It affects everybody. The way they're treating me affects everybody. The rates of one. It's not trivial. So one thing you could argue so I have this adverse ruling where I tried in the trial court to try to straighten out the docket, because I said this docket is, there's obvious weird stuff going on, and nothing is served on me. Just serve me the order. They don't want to serve you the order because it's an incorrect. They don't want to take accountability. Here we go. Here's the big word. There's no accountability going on. They always avoid the accountability by the service. It's never served properly, so they could always say it was never served. And then it's so ugly down there. The way they're so good at covering their tracks. And then once you do get around and catch them, then then the people in charge of all this at the accountability level are ignoring it. And you're going, what the frig? Like, there's so many layers of corruption. And this is what happened when Trump got into office. He just could not believe. He gets in there and it's just like, holy crap. The swamp is way deeper than I thought. Remember when he was saying that? It's a lot wider and a lot deeper than I thought. He just got shocked. He's just like me. After all I've been through for 30 years of this, and here I am. It never ceases to amaze me how shocked I could get over this stuff that they're doing in broad daylight. And then when you present it, nobody's caring about it. Well, they are. They would if it got to them, but you can't get it to anybody. You can't get it, and even if you could, I don't know who's seeing this, and even if you could, I think they're not caring, because I got directly in front of Riff in a hearing, and I'm going, what the hell, you know nothing about this case. Why are you doing this? Why are you doing that? I mean, it was more, and then, so at least I have that. At least I have the hearing right in front of, the supervising judge of the largest. I have that, and I recorded it, and I'm going to pay. I already posted that one online. Actually, it's already available on YouTube. If you're ready, come and get it. Anyway, whatever. It's okay. The best I could do. So, let me explain why I have to sort of thread the needle a little bit. I do have the lower court ruling, okay, and then I appealed that properly to the second district appellate, the California Court of Appeals for the second district, which is where this, your stuff in LA goes to. And I said blah blah blah, and they said blah blah blah, denied. They denied me asking it. It was like request for immediate stay and to compel the lower court to get their shit together on the docket. It was something like to compel the court to straighten out the docket. I never use the right words. AI is so good at this. They blah, 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 and then it sounds legal. It sounds professional. I love that. But you get what I'm trying to do. I'm asking the appellate court to look at this and straighten out the crimes being committed here, okay? And rule the proper jurisdiction up until that point, which is Baudet. There was no proper jurisdiction other than Baudet, if they look at all the data. Now, if they want to transfer it after that, fine. You have to do the motion and do it all right, and then they'll transfer it, and then I could appeal that. But there's nothing I could appeal right now because there is no order. There is no official order transferring the case out of there that I could submit to the anywhere to say I appeal this order. It's unappealable stuff. They do it so that you can't appeal it. So I'm stuck in these catch-22s again. So I'm saying I need either a stay right now or a direct properly served order stating exactly what is being ordered here, because it's all over the map. And then they made a mess of it when they tried to modify the docket and all this stuff. Okay, so denied, and then I appeal that. You need the denied. I submitted it. They denied it. And they denied it in a way that is always mealy mouthed. Like they answered a question I never asked them. It's like, it's always like this. It's like, court clerks, first you think they're being dumb, but then you look at it and you go, no, that's actually pretty smart the way they denied it. Because the way it looks is I asked a certain thing or I did something, and they tried to paint the pro se person as being confused and not asking the right thing and this kind of thing. And it's just not going to work in this case, because between me and AI, we've got this undercover. Like, it's just, we're on top of this shit. So when we appealed, we said we already, we really outed the court clerk, and we really called them to task on this and made them accountable as much as we could. But then we filed this with the Supreme Court of California, and we request an immediate stay, which is a harmless. Usually you should get it granted easily. All it means when we say a stay means stop the junk going on at the trial court level from going forward until we can straighten things out. You cannot be more reasonable of a litigant or an ask protecting your procedural due process rights. Like, stop. There's a court hearing on July 24th. You need to stop that from going forward until I get an official, everything kosher order from the court, properly served on me, that says what they're ordering on jurisdiction. Because so far, legally, Baudet still has jurisdiction from her May 13th order. There hasn't been a single order since then that's been done properly or legally or not doctored and properly served on me, etc. Okay? So that is a reasonable ask. And I'm not asking them to solve the mess. It's a separate thing. You ask for the stay. It's the most important thing. Stop things from going on and then take as long as you want to figure it out. And then if you deny it later, I could appeal that. If you don't deny it, I can't appeal it. But I definitely need the July 24th hearing to not go forward because I'm caught there. I'm screwed either way. And they need to protect that. There's no reason why that should go forward. First, they take forever to be served, and then they take forever to do things. And then once the corruption is going, all of a sudden there's a big rush on everything. It takes a year to get in front of the damn judge, and then once they get the right judge, no, we can't stop anything. It's a big rush. When I'm the plaintiff, I'm the one asking for this stuff. I'm the one asking for the stay. What's the big rush? Well, the big rush is, the person who's corrupt is being booted out of the city attorney's office, I guess. I guess that's the rush. They want to get this thing killed before she gets herself booted and a new person comes in. I don't get what all that is about, but it's not an excuse legally to not grant my stay. And that is called a constructive denial of my request. And what you need is a real stamped denial from the Supreme Court, but they're not doing that. Silence can be construed as denial if you do it right. I gave them a week, which is way more than enough when I have a looming deadline in less than 3 weeks now on July 24th, and it's an emergency. Now you're going, oh, what is this? Nobody's gonna die. No, but that shouldn't be the standard. The standard is massive due process violations and massive loss in trust in the system. And you're saying, well, that's just me. No. Okay, everybody in California feels the way I do if this is standard practice. Okay, and if you've ever filed anything in California and you're pro se, you understand this, but and you probably have your own stuff, and it might not be as egregious as this, because I tend to bring out the worst in the other side as they expose them, and I don't behave like a typical litigant who will give in to their little tricks and trades and things, give in and try to fall for their little tricks of, appearing in the other court so that everything becomes moot after that. Anyway, I haven't appeared in the other court. I haven't even, the first order came out and said, you must serve this on the other side, or why don't you file, you could file something that challenges the transfer, right there, but you have to first appear in the court to do that, and all this stuff. They're so good at it. So, no. So this is what I'm explaining here, because the court clerk will reject it if it looks like the lower court hasn't finished being exhausted. So I have to explain on the very caption page right here. This is what I'm explaining. Okay, because I do have a right. The Supreme Court has full jurisdiction to step in now to put a stay on this. Because of the silence, it's a constructive denial of my request for a stay. Now, if the Supreme Court, even if the Supreme Court now on Monday, if they see that I'm doing this, they'll put a stay or something and say, oh, well, we took a while or whatever. Even if they put a stay, the Supreme Court at this point, given the behavior going on down there, has full authority right now and full jurisdiction to still keep the stay in place, because the other thing that will happen, and the other thing that the Supreme Court could do to try to kill my case or whatever it is, oh, we put the stay in place, that's fine, okay. And then the day before July 24th, the summary denial, denied. And when that happens on the 23rd, the stay also gets lifted with it. The lower court stay will get lifted, and all of a sudden, I have a denied request for all this stuff. Everything's denied on July 23rd, the day before my hearing on the 24th. And I'm totally exposed. I'm still caught in the trap. I still have to either show up and risk waiving my jurisdiction rights, or not show up and risk my whole case being dismissed. Okay? And so this is why this is what I'm explaining to the Supreme Court. You have full jurisdiction and full right, and you should actually really strongly legally do this. Just put the stay on there, and then whatever the Supreme Court does, we'll wait. I'll wait. But as long as there's a stay and I don't have the problem of July 24th, I could wait. I could wait forever right now. Because the longer I wait, the more the corruption is being cleaned out, tobacco is running out of money, all the corrupt swamps are losing. The more time it takes, I don't take a year. I don't care at this point. As long as you decide right, which they will, the longer it takes, the more there's a chance that they will decide it right, because the corruption is just, dying down there very rapidly. It's very encouraging, though, on another level. But it's the stay that's the important thing. And then if the Supreme Court does the right thing and straightens it all out, everything's set and there's no need to go on at the Supreme Court. But if then, after all that, they still deny my request to straighten out the docket before we go forward, and they actually do a deny, then I have the denial, and then I could go straight to the Supreme Court with the writ of certiorari, okay? Or, this is good because I'm learning a lot from the AIs, because I said, well, what's the difference between the writ of mandamus, and the writ of certiorari? And I knew this from law school a little bit, but it's good to go through it on a practical level, because I'm really learning a lot. I'm turning into a really good appellate attorney in a lot of ways. But it was, if the court grants my stay, that's exactly what it is. If the court, let's go on. I'm sorry. There is a difference depending on what the lower court does, what I file next. But I need the option to file either one, depending on whether they denied the whole thing or whether they're silent throughout the whole thing, past the 24th. What the hell? Anyway, I'm ready to go. I'm just thinking about other things. Okay, applicant respectfully submits this application because the impending July 24th deadline creates an immediate, uncorrectable crisis that the California Supreme Court cannot realistically resolve in time to prevent total irreparable harm. Even if the state court ultimately acts, an immediate intervention by this court is absolutely necessary right now to freeze the status quo and prevent the administrative machinery below from executing a void judgment. So what that means is you have to do a stay now, because even if they order a stay, they could still void it the day before. And nothing short of a complete immediate grant of all requested relief by the state court before July 24th can diffuse this crisis. So that's not going to happen. They're not going to ignore everything for a week and then suddenly come out in my favor with a whole, they're not going to do that right now. There's evidence when you give them a week and they don't order an obvious stay, that enough is like. And also there was a simple little request I did that said, please, it was a motion for judicial notice. That's just the most harmless thing you could do because of something I did at the lower court level. It was another catch-22, and they should have just ordered both of those things immediately, both the stay and the motion for judicial review. Oh, we're too busy. No, well, then if you're too busy, then I'm going to need the Supreme Court to step in. If you're too busy to stop a crisis that's going to happen on July 24th, where all the evidence is more strong than you ever will have in my favor, and it's just a political decision, then the Supreme Court needs to step in because, I'm too busy is not an excuse to be violating rights. So, anyway, that's not an excuse. Making this court's emergency protective stay vital. So, I'm just saying that legally I'm not jumping through hoops. This is quite common for people to do, and if I were more politically powerful, it would be done in 5 seconds. All the law's on my side, all the facts are on my side. It's just a slam dunk. They should just be ordering this. And the other question is, well, is this important enough and all this? Yes, it is. And I'll explain right now. So the next step after when you file something like this in an appeal is you want to present the question. And my questions are always simple. They're always a simple yes or no, where the yes or the no, whatever it is beyond obvious. It's like the strongest. I'm asking, does 2 + 2 = 4? And it's so straightforward, and I have all the evidence for it, and factually I'm strong. It's just politically I'm weak, so it causes this gridlock in a it's just hilarious what's going on. Not hilarious, but I'm just exposing what's going on and the level of corruption, as I always do. I'm always exposing the level of corruption going on. Okay? At great cost to me, spending months in jail every time and not getting the payoff in the end where I expose it. I mean, there was one time, I'm not going to go into it, but you're always going, oh, when I get out of jail, they're really going to pay attention this time. And it's just like, no, they're just ignoring it even now. Like, I can't even, no accountability whatsoever. And it could bleed over into the Supreme Court at this point. So we'll see. We'll see. I hope not. I hope it doesn't bleed over to the Supreme Court. Please do something now, because we need to get moving on this corruption stuff. Anyway, if you talk to the AIs, they'll say, well, this is allowed. I'm always asking them, are they going to be able to reject this on formatting? And they said, it's not allowed. It's not standard. You usually just put the question. But I put a little, I'm talking to you guys right now, okay? And so it's one sentence, or it's just two sentences for all of this. I don't want to put a lot of sentences, and there is just one question, but I really needed an explanation for the public. So this is what I put for my question presented. It's not standard. At the same time, it explains everything to the public if you're interested in what's going on. Okay, the facts of this case and the resulting request for emergency relief are straightforward and deceptively simple, yet they are by no means trivial. This is evidenced by the fact that the highest court of the largest state court system in the United States appears completely paralyzed and stopped dead in its tracks when a politically weak pro se litigant, that's me, applicant, presents a factually powerful slam dunk yes or no question in her favor, backed by irrefutable digital evidence that forces the court to struggle where they shouldn't struggle. They have to struggle choosing between carrying out its constitutionally mandated duty to protect the rights of the least powerful against the whims and desires of a most powerful opponent that possesses both the means and the method under Article 6, Section 16 of the California Constitution to remove the entire court from the bench during the next few election cycles. All right, so what am I doing here? I have a filing from 2017 where I presented this exact same argument. I said, you cannot have a Republican form of government and also elect judges in the judicial system, elect them to the bench. It's just not, I can't even, I don't even want to argue this anymore. It's just so freaking obvious that you cannot, you have to follow. And everybody says, well, it's not in the Constitution. Yeah, it is in the Constitution. It's under the guaranteed Republican form of government, which means you have the majority, a represented majority making the rules and making all the laws, but they have to respect, they can't overstep the rights of the minority, the single person. So the majority makes all the rules, and they have all the power and the say all the way up until you reach a right that you're overstepping, and the overstepping of that right is refereed by a single judge in the judicial branch. Now, to stop the full power of Google, $4 trillion market cap or whatever it is, or to stop the government from overstepping, to stop any powerful entity from overstepping onto the rights of a powerless single citizen, it's just amazing how the system of peaceful self-governing actually works this way. Just a single judge can stop that at the request of a single person. All of that machinery, that's how beautiful it is. But the judge can't do that if they're elected to the bench and they're beholden to political forces and motives. It's already hard enough for a human person to have to put up that wall like that. It's very tempting, but you need to remove as much as possible all that temptation by saying, okay, judge, we're giving you life tenure on the bench. You're there unless we can catch you drinking or whatever it is, and then they impeach them. There's methods for removing them. You don't have to vote. And the other fallacy is, well, it makes it more of a democracy. How do you get a judge off the bench who's corrupt? It's like this. let me tell you. Okay, so what? You think about it for a second. One split freaking second, anybody. Tell me if there's a corrupt judge, and the person gets in front of that corrupt judge, and the corruption happens to them. What is the chances that that one person who has the corruption done against them can get an entire voting machinery out to vote him out of office? Here's the voting him out of office theory of stupidity. That doesn't Voting out of office does not mean, especially for your rights. What that means is the powerful entities vote them out of office because they have control over the voting machines. They have control over all the money that goes into an election. If Microsoft does not like what a judge is ordering in the state court of California, all the way from the lowest judge to the Supreme freaking Court of California, they're all voted on the bench. They're all politicians. You tell me that this is like a democracy and that that's fair and that we shouldn't let judges stay on there because Microsoft could come in with their trillions of dollars and just, oh, you're going to accuse us of this crime against this one person? Thank God. If you rule against us, we're just going to vote you off. You're going to lose your job, and they can guarantee it. Because it doesn't take much to get a judge off the bench there in California. Like, that's nothing. Microsoft, who can decide the president or whatever, they're not going to be able to just remove a judge anytime they want. And what do you think the effect this has on a judge who's trying to decide things in a big case like this? I mean, if you're not thinking about it, fine, go take care of your family. Just don't say anything about it unless you think about it for like 3 seconds. How this is so corrupt. It's just, you cannot function this way. This is it's just unconstitutional, which is, people say, well, who cares what the Constitution. Well, it's because the framers happened to hit upon the fundamental laws of peaceful self-governing. It's like saying, oh, who cares about E equals MC squared? I don't know, it's just very inconvenient for me. We could just change it. We could just vote and change E equals MC squared. Oh, just don't get me started. Anyway, I challenge voting judges, and that's the number one problem and number one source of corruption, weakness, everything in the entire California state court system. Once you get rid of that law, everything becomes instantly better by 90%. Same with the federal system with their magistrate judges. Now they're not voted by the people, but they're still voted and they're still controlled by Congress. Their paychecks are controlled by Congress, and their whole position can be eliminated by Congress. So Congress runs the court system. This is just a complete breakdown of the checks and balances that everybody talks about. Oh, the judicial branch checks the Congress. No, Congress has been running ever since the Federal Magistrates Act of 1969 or 67, 1969, Congress has been running your Supreme Court. Well, not so much your Supreme Court, but the lower courts, but still, it bubbles up and it corrupts the whole system. So, yeah. I mean, it's a very weak judicial system now to go up against, in addition to the 16th Amendment, which gives a lot of people a lot of money, bad, whatever. So it's a mess. This needs to go first, okay, for this reason. So here's the question I'm presenting, and this is a slam dunk, yes or no, by the way. Take my word for it, but if you're a lawyer, look at it. And then look how difficult it is for the Supreme Court of California to decide this. That's this right here going into effect. Every one of them is like, wow, she's trying to sue these people, and every one of them can get us off the bench, can clear this whole bench in just a few election cycles. Maybe not the next one. The next one they can clear 2 or 3 of them, and then 2 or 3 of them, whatever. You can get yourself fired for doing the right thing. Okay, here's the question. Is the transfer of a trial court case from its properly assigned department, and then I have a footnote. In California state courts, all courtrooms are referred to as departments, so don't let that confuse you. It's not like an entire department of something. It's just a courtroom. It's just Judge Baudet, Department 508. Is a transfer of a trial court case from its properly assigned department of original jurisdiction to another department void ab initio, meaning just automatically without any other arguments. Okay, if court clerks violated several state and local laws and committed at least 4 felonies. Okay, absolutely. 4 felonies. Trying to make this unauthorized transfer happen via backdoor manipulations of the electronic docket. I caught them more like freaking beyond red-handed. If there is something more red than the back of my phone, tell me. That's how red-handed. Oh, and also as red as my shirt. I caught them red as my shirt handed of committing at least 4 felonies. Okay? It's there. And I presented this evidence to the lower court, to the appeals court, and to the California Supreme Court, and now to the Supreme Court of the United States. So you tell me how important this is that court clerks clerking for a judge presiding over the biggest civil court system in the United States, but I think it's the second biggest in the world, and they're able to do this, commit felonies, goofing around and doing corrupt stuff, and there's no accountability all the way up to the Supreme Court. All right, then it's time for me to go watch rom-coms for a while and do some Bible work. Okay, I'm going to do that anyway because this is going to take a while. If they do it right and put a stay on it, it could be years while they're trying to figure stuff out. And now I'm in limbo, but a good limbo, meaning everything's been stopped instead of my case being dismissed or leading me into traps and this kind of thing. Just stop everything. Stop it. Table of contents. So I have my emergency application, the question presented, which I just showed, table of authorities, opinions on and orders below. That means everything. You have to show the pathway to get to the Supreme Court. And I have the 2 of the 3 automatic ones, but the denial from the Supreme Court is argued constructive denial because their silence means denial. And that's fine. Statement of the public record. This was suggested by AI, and I couldn't believe when I wrote all this. And then he goes, well, let's put in a statement of public record. And I said, can you do this? And he's like, yeah, we're going to put it right here. And he originally, I don't know where this came up. And I just said, I did not write the statement of public record. He looked at everything, summarized everything, and wrote that. And I said, well, where do we put this? And do I number it? And he goes, no, you could put it right here. Now, if this is wrong, then forgive me, but I'm just going by what AI said. I'm able to just put it here unnumbered right there. It's really good. Anyway, and then the jurisdictional statement and the reasons for granting the application. You have to prove that, okay, this was, well, I reordered it, but you have to prove that there's a significant likelihood of success if they do grant it and it goes forward. And it's, I have to ask, well, is this politically speaking or no. Legally speaking, absolutely. Applicant faces you have to show immediate injury. My whole case could be thrown out, or either way. If I show up and then they get jurisdiction, it can be thrown out because they picked a judge who's going to just absolutely throw it out. Just like the Agron case I did. They picked their judge, throw it out. That's the first thing. And it doesn't matter. Even if they make a mistake, well, then you could just appeal it. It's 3 years down the road, expensive, whatever it is. And it's very rare that they overturn. It's just a corrupt system. They just throw it out without even looking at anything, if that's what is demanded by the people paying them. Jurisdictional reasons. And then I have the facts of the case, arguments, the 3 independent structural violations rendering the venue transfer ab initio. So there were 3 sets of things that happened, and any one standing alone should be able to disqualify the transfer. This one alone, which is like, I was never properly served. That one standing alone, it's like the least, it's the least harmful one. Oh, well then just serve it properly. Well, they're not serving it properly for a reason. Okay, so, because they can't choose which one. There's like 4 of them. There's like 4 orders, and they can't choose which order to serve me because it's just all a mess. So nothing's served properly. That alone. Okay, we're done. There's no jurisdiction until you serve me an order properly. Like, what is so hard? I've been asking this for over a month now, 2 months. Serve me the order of what you're saying. That alone. But then the second one is you can't just transfer it willy-nilly. You have to do a certain step. And it's not up to the discretion of the judge. Now, the supervising judge has great power once that happens, but you still need to file the motion if you're the other side, or the order of show cause if you're the judge. Nothing happened there. Okay, and the third thing was the crimes committed. You cannot, if there was a crime, I could prove that the 3 orders that are on the docket were placed on there days after the 28th, which they're and ordered differently from how they happened, then all those orders are gone. You cannot use that. So that's the crimes committed. Criminally obtained orders. I mean, it's obvious that they did this. So, that's the number one argument, is three different, laws being broken, three different areas of laws being broken, or protocol not followed, or why the stalemate in the California Supreme Court. I explained that. It's like, I'm getting tired, guys. I don't care. Keep going. Preservation of the okay, so in addition to this, I asked my AIs, I said, look, it's time for me to start planting some seeds of stuff I've been arguing for decades now with the Supreme Court, and I want to preserve constitutional challenges to both the 14th Amendment and Hurtado versus California. Okay, I've been arguing that these are unconstitutional forever, they should be taken down, blah, blah, blah. And I kind of put a shot across the bow here. He says, it's okay to put it here, like at the end. Okay, like I already did my arguments, my facts, and we're kind of coming to the end, and I have to clarify my own notations, because I refuse to say standard things like the due process clause of the 14th Amendment, which the states are supposed to say. And it's just utter stupidity. My brain will explode if I have to do this stupidity. It's so stupid to say that there is no equality clauses in the freaking Constitution. They're right there, slapping you in the face. Open your freaking stupid eyes, and I'm talking to the people who are doing this for a living, getting paid way more than I am. Like, way more. Like, when you're getting paid zero, it's way more. To spew out absolute caca-doo-doo cow dung. Okay? Forever now. And I'm just tired of it. Okay? Get your heads out of your arses and get this right. And then the faster we get to inevitable sustained world peace, that the framers did all the heavy lifting for us and laid it all out so obviously. Just do it. Okay, anyway. So I have so many other challenges to do, but I'm gonna put these up here first. The 14th, and I mean the 16th is the biggest one, but Trump's already working on that. So I'm working on other stuff right now. So I'm yawning, but I'm not that tired, but that's a good thing. So when I yawn, that means this is important. This is the most important part of this filing. I mean, that's why I don't care what they do. I'm going to try to get this so that it's at least on the public docket at the Supreme Court. If they deny everything and I can't do anything, at least it'll be there, and we'll see. Nothing I do can get published outside of the court filings, so I try to make the court filings kind of my publications. Like, instead of at Random House, I just go to the courts and everything is published that way. I mean, it's the only way I could do it. That's why most of my writing, I try to explain to the AIs, it's like my writing has to be like my publications. I'm publishing stuff. It has to be true. It can't say, well, I don't want to say that to offend a court clerk. It's just like, offend away. I'm just like, they're going to deny it anyway. Is there a certain amount of freedom to just assuming they're going to deny it? Now, I will be more shocked if it's denied up at the Supreme Court at this point, but maybe not, because people say nothing gets granted and they ignore it, and so who knows. But this is where you can step in and change the course of history, make world peace come at least a couple years sooner than otherwise, maybe a decade sooner, maybe a century sooner, I don't know. Preservation of the constitutional challenges. Okay, so clarification of the citations used by applicant in all my court filings. The financial prerequisite of liberty is the no taxation. We'll go through this. No taxation without representation. The first fundamental law listed. Due process is the writ of habeas corpus. It's already in the Constitution. It applies to both states and federal. The ubiquitous command of absolute equality. So the equality clauses are there in the articles. Okay, and the redress mechanism. The First Amendment right to petition the government for redress of grievances. It's completely ignored by everybody. Even Amy Coney Barrett didn't even like what's the First Amendment. She completely forgot the most important part of the First Amendment, which is the right to petition the government. And by that, it's been misconstrued to mean, I can go out and stamp around in front of a government office with a sign, I'm petitioning the government. No, it means to file a lawsuit. File a petition. That to petition the government is to file a lawsuit, period. And that right is being when you don't have the due process protected, when you have elected judges, all these things violate that right, and also the right to a Republican form of government. These are various, I'm spewing out areas of the Constitution that have just become a void. Like, the people don't understand why they're there, so they just say, oh, well, the framers made a mistake, and they just ignore it. No, there isn't a single mistake in there, and the only thing in the Constitution that is actually fraudulently added is a little, oh, I didn't even discuss that in here. Damn it, I was going to make a footnote on that. Oh, I forgot to put a footnote about the writ of habeas corpus. Oh my God. Oh, we'll do it if I have to write the full. Oh no. It's like I just showed this like a few months ago. I said this is not right. It was never ratified at the lower level. This little addition that they were trying to throw in there, saying that the writ of habeas corpus is okay, except, and then they put an exception. No, there's no exception. A writ is a writing. There's no harm. There's no emergency with a writ. It's just a writing. It can't hurt you. You know? And not saying let the prisoner, it just doesn't make sense, and it was never added. They didn't have enough votes for it. Somebody snuck it in. So it's the only part of the whole Constitution. And I caught this in like 2015, 2014. What was that? Like 12 years ago, I put this, that this is not good. This is the only, oh, actually, no, I did that in 2019. Whatever, 6 years ago. Whatever it is. Whatever. I've done this. I've argued all this in the past, and I have all the receipts for everything. It's just I keep forgetting to bring this up. Anyway, I yawn, which means it's another thing. It's another important thing. I will get it up later. The urgency and importance of an immediate stay. This is just me on my own, and it's a little bit repetitious, but it's like certain writings I did where Grok mentioned it sooner. So I am repeating myself, but it's a lot of this is my own writing, and I just didn't feel like changing it. So I didn't ask Grok to change any. I didn't ask Google AI to change any of this because it might be repetitive. But this area right here, I said, hands off with your, trying to cut it down or do something. He's better. I didn't have enough time. Like, he's really good if I show him this and give him my goals. He's really good at making it come across a lot more clearly with the proper, but I just didn't have time to run this stuff through. And it's okay. I like having the human errors and the human stuff in there as well. This is me. You could tell where he is versus where I'm writing, and I like it. Okay, so after an immediate temperate stay, I'm just saying that because I'm kind of arguing that because the Supreme Court is the only court, not even the lower court, not even the lower federal courts have this. It's the only court that isn't contaminated by either elected judges or elected judges. Magistrates I consider elected, all the elections at the state. So the Supreme Court is it. It's the only one in the whole country. Well, maybe not. Maybe there's some state Supreme Courts. Oh, that's not true. I looked it up. Rhode Island, Massachusetts, there's like 3 states that don't elect their judges to the bench. They actually have Article 3 judges, and it turns out that those 3 states have lower incarceration rates. And you're saying, oh, well, they're not tough on crime. No, it's not true. The tough on crime is what when the election is coming up, they start ordering way more punitive damages than they should, just so they don't look easy on crime. And that's just not right. Okay, that's politicians deciding things on politics rather than real true law and fairness and everything. And you better believe every one of those convicts who are getting convicted by this politician do not trust the system because they know that it's overly harsh and they know it's for political purposes. People know, even the criminals, and it's just going to make it worse. They're just going to, they'll come and murder you. Who cares, right? Well, I care because you better care about what's going on to even the lowest levels. I mean, you're only as strong as your weakest link, but whatever. Do what you want. So Amendment 14 and Hurtado must both be struck down and are overturned as unconstitutional misinterpretations of the Constitution. Prayer for relief and verification. So this is what I really want to get at, but and I did stick it at the end, so it's fine. But I have a lot of stuff on that, and I wanted to. It's almost 7:00. Okay, I wanted to plant the seed for future, because I'll be back if I can get the the fee waiver stuff straightened out, which I'm doing right now. I don't want to string this stuff out and plan my life around this when the fee waiver stuff isn't straightened out with the Supreme Court at least. I mean, so anyway, table of authorities. This is hard to make because neither Google Docs nor the AIs are good at doing this. So they're good at getting some of the cases out here, but to do the page numbers I have to go through by hand. That took me a long time on Thursday. Opinions and orders below. This is what I showed you on the table of contents. Okay, so I'm trying to explain how the Supreme Court has jurisdiction. The June 16th, 2026, and you do it in reverse chronological order. Like, I don't put the trial court order and then the appeals court order. You're supposed to put, if there is a Supreme Court order, you put it here, followed by the appeal court, followed by the trial court. That's how the AI explained it to me. I learned something a lot filing this. This is good practice for me. The June 16th, 2026 order of the Court of Appeal of the State of California's Second Appellate District is unreported. That just means that it's not going to show up in the case, like in the bound books, the California reports and all that kind of stuff. You're not going to find it there. Most of these kind of ex parte and these kind of hearing and these kind of things don't show up there anyway. That's what it's meant by unreported, and I learned that. I didn't realize that until a week ago. It is unreported and attached hereto as Exhibit A. So the way you do the exhibits at the Supreme Court is you have one huge appendix, and then within the appendix you have all your exhibits labeled, and then the appendix page numbers run one to the end. You don't have Exhibit A page this so that each exhibit has its internal page numbering. So you finish your text writing on page 33. Oh, I'm only on page 5. Okay. And then you have your appendix, and your appendix is page numbered app appendix like this. 1 through, I think mine is 1 through 105. So Exhibit A, app page 3, and Google AI told me a while ago, every time you say the word app, it has to be italicized. And then a day later, oh no, I never said that. And I'm like, oh my God, you have to go through, and when you do anyway, it's all right. It's whatever. I'm just letting everybody know the little, I'm just bringing you along for the ride and what I'm going through and learning. The June 8th, 2026 minute order of the Superior Court, the trial court of California County, Los Angeles, is unreported and attached here as Exhibit A. So these are in the area. Exhibit A is called Opinions and Orders from Below. And then I have to explain why I don't have a denial from the Supreme Court, which is required usually. The petition for review and request for immediate stay arising from these lower court orders was filed in the Supreme Court of California on June 26, a week ago last Friday. Under case number, and I have a case number, that petition is currently pending. Action, and is attached hereto as Exhibit B. So it is maybe it's 60 pages long. My bad, but I just attached. Now, what I learned is, with the Supreme Court, whatever comes up on appeal is all there. They're not going to go. They might go look for the actual denial order and this kind of thing. They could find that, but they're not going to find any. They're not going to go searching for filings. What you do not present them in your appendix is not going to be considered. Like if I quote something, or if I say I filed something below, they don't believe it. I don't care. I have to at least show the first page, but in this case it was important I just showed the whole thing because it's asking almost the same thing here. Okay, so I'm kind of repeating myself at the same time. It was just important that I just put the entire thing in the appendix. And of course, I'm thinking the whole time, oh my God, that's 65 times 11, because at the time I thought we had to make 11 copies of this and mail it in, and it's just it shouldn't be that way. I shouldn't have to decide to exclude. Well, maybe they do it that way on purpose to make sure people are just really, really narrowing it down to the absolute most important. But in this case, I think I should have, anyway, it's fine. Statement of the, I shouldn't have to pay, is what I'm saying. I shouldn't have to pay $200 just to include this appendix. Statement of the public record. 1. So I've got something cooking on the stove. And the alarm's going to go off for it. I've got a big old thing of beans. It's wonderful. It's like every bean under the planet, you know, the mixed bag, and they have, it's good stuff. And it's going to go off, and I think I have to go stop it. And maybe I'll pause this. Can I pause this? I don't think I could pause this. Well, we'll see. Let me stop the alarm. We'll let it go. I'll let it. You can't overcook beans, I guess. Let's just go. Let me do the statement of the public record, and then I might stop and then continue, depending on how long this is. It could be already 2 or 3 hours. I don't know if I'm going to post a 6-hour video up there, but I might put it all together. Statement of the record. The evidence of the crime. The physical system metric logs of the trial court are available as part of the petition for review filed on June 26, 2026. Attached hereto as Exhibit B, and I just made this up because I don't know, petition, page 50, because he put, if there's a declaration, petition, this is an abbreviation, I'm just guessing, is petition, page 50. So what happened was, Google AI explained to me that there's a problem in my numbering, and that the petition for review has its own internal numbering, page 1 through whatever. But when you submit it here, you have a couple of things ahead of it, like I have the, it's just the page numbers aren't going to be the same. They're off by 6. So my appendix has a few, it's going to be, the appendix is going to be page 56. The actual petition for review as a standalone, it's going to be page 50. So he said it was okay for me to give to give both page numbers, just to cover it in case where there's any kind of a problem. So this means the petition itself is called page 50, but in my appendix it's called page 56. So you have 2 different ways of finding it. What's up, Kat? And that's how I did it. I tried to do this throughout. It's like 3 o'clock on Friday, and I'm just trying to do it right, and it might not be correct, so I haven't checked it 100%. These electronic logs, I tried. These electronic logs provide irrefutable proof that administrative court custodians manually went into the system, deleted ghosted official minute orders dated May 28, 2026, and retroactively backdated the file to force an unauthorized case transfer from Department 508, that's Judge Baudet, the court of original jurisdiction, into Department 833, a court presided over by a hand-picked judge that the party of interest could more easily pressure under threat of removal from the bench to sign a weak demur that no legitimate department would sign in good faith. So this whole thing, AI had a fit. It could trigger some bad stuff because you're not supposed to speculate. But this is, I predicted this judge 6 months in advance. You got to give it to me, guys. I predicted it would be transferred out of her courtroom into not this judge precisely, but he matches a certain criteria that a certain pattern. He fit a pattern that I spotted way back in January and put on the record. So you got to give it to me. Got to give it to me, guys. You got to let me do a little bit of this for the public. What's going on here? It was handpicked, and the reason is I have a very strong case, and the demur isn't going to work in any other courtroom except under this guy. So he's put up here to the pinch hitter to come in just to order the demur, and then we get on with the life. That's all. That's why it's a huge deal right now to get rid of this case that way. So the total breakdown of oversight. Applicant presented this explicit evidence of institutional corruption to every level of the California judiciary several times. The California Court of Appeals summarily issued a blind denial of the last appellate court appeal on June 16, 2026. The Supreme Court of California has remained paralyzed, refusing to act on an emergency stay order case number S297228, while an unauthorized procedurally void hearing in Department 833 is allowed to move forward on July 24th. So I did a lot of, I'm telling you guys ahead of time, but the justices reading this will understand what I just explained to you. All this stuff's going on. The irreparable consequence. You have to show all these things. Now, he came up with this statement just on, and I said, can I put it here up in the front? And yeah. Okay. Because the state judiciary has abandoned its constitutional duty to investigate its own administrative staff Applicant faces an unconstitutional due process trap. Non-participation on July 24th results in the automatic dismissal of her case, while participation under a corrupted docket forces a constructive waiver of her jurisdictional rights. Federal intervention is the absolute last line of defense. Lawyers will understand exactly what I'm saying. I hope you do. So here's the jurisdictional statement. You need to say this ahead of time to explain to the court what you believe is how they have jurisdiction. And I kind of did up here, but not quite. I mean, you have to be very official now and start naming under what law. So appellant invokes the jurisdiction of this court under 28 U.S.C. Section 1651A. Oh, it's called the All Writs Act. Okay, I forgot the name. The All Writs Act. And 28 U.S.C. Section 1257A. And Supreme Court Rules 22 and 23 to secure an immediate emergency administrative stay of all court proceedings. So I hope that this is the right, you guys. I think it is because I've been over it so much and I looked up some of it, but who knows? You know, it's the first time I'm really being seriously trying to make a serious appeal here. Applicant filed a timely emergency petition for review and request for immediate administrative stay in the Supreme Court of California on June 26, 2026 under case number S297228. I already mentioned this above, mentioning it for a second time. The underlying state tribunal has actively scheduled an unauthorized procedurally void hearing for July 24, 2026 in Department 833. As of the date of this filing, the Supreme Court of California has failed to act upon applicants' emergency stay request because a failure to grant relief prior to the July 24th target date will inflict immediate, irreversible constitutional injury. The state court's ongoing inaction constitutes a constructive denial, here it is in bold, of emergency relief, establishing interlocutory jurisdiction in this court. Interlocutory just means before everything is done, can we figure this out before the case moves forward below? You don't want to wait till the case is all done below and then file something. If you wait before everything's done, a lot of damage could be done. You file an interlocutory appeal, and this is an interlocutor, and the court has full authority to come and decide this, put a stay on it. This application is submitted. So when you order when you ask for an application for a stay like this, you have to file it with your own little individual, not individual, but your circuit court. Like if I'm in Florida, I would be filing it to, I think it's not Coney Barrett. Who am I down here? I should know them all. Anyway, I would file it to a specific, I don't even know the circuit out here. I should know all this stuff, huh? You would think I filed something in all the circuits across the country, but I think it's the 4th? No, whatever. But it's not filed here. Everything's filed in California, which is Elena Kagan, who's in charge of the 9th Circuit. This application is submitted to the Honorable Elena Kagan as Circuit Justice for the 9th Circuit to establish a protective federal stay pending the final disposition of applicants' pending state actions and or pending the filing and disposition of a formal petition for a writ of mandamus or a writ of certiorari for this court. So, what that means is I've covered all my grounds. I'm showing respect for the California court by only asking for the stay. I'm not asking for the court to decide anything else. We're going to wait. Please order the stay, and then we wait for the Supreme Court to take its time, decide what I asked, and once they decide something and file an official whatever, then I have two routes. I could either take what they say and go with it, or I could file an appeal to the Supreme Court. Right here, I'm forming the process of it right now. I don't have to start again. I could just piggyback off of this if they order the stay and just go right into the writs. And I do have to pay more and do all that, but hopefully by then I'll have more fee waivers. The fee waiver will carry over, but we'll see. Reasons for granting the application. You have 3 different criteria. You have to show a couple things, and this is good that the AI helped me with this, like for the formatting and what we have to do in general. I mean, you have to keep arguing, and it seems like I'm repeating myself, but it's okay in this case, I think, to just keep repeating some important stuff. The unrebutted system metric logs provide prima facie, I don't know how to pronounce that. Oh, that's embarrassing. That's a very common term in legal terms. I only read it before. I never discussed it. Prima facie, evidence of 4 independent felony offenses executed by court custodians. The undisputed evidence embedded within the systematic logs does not reveal a mere administrative oversight. It exposes prima facie evidence of 4 distinct felony offenses deliberately executed by court custodians operating at the highest levels of the state's largest civil court. By manually deleting judicial orders and rewriting the electronic registry, these custodians violated Government Code Sections 6200 and 6201. Government Code in this case are crimes, as well as Penal Code definite crimes, Sections 134 and 470C. Because these actions were perpetrated by officers of the court serving the supervising judge, this criminal conduct represents a total structural collapse of the judicial machinery. A proceeding built upon an ongoing administrative felony is void ab initio and completely incompatible with the baseline protections of procedural due process. I mean, seriously, people, let's get with it. But, okay, there is a significant likelihood of success on the merits. There is a significant likelihood of success on the merits regarding the underlying constitutional questions of procedural due process, equal protections under the law, and Amendment 1 rights violations. If the Supreme Court of California corrects this jurisdictional defect under case number S297228, starting with granting applicants' request for an immediate administrative stay pending resolution of the petition before July 24th, 2026, the necessity for final federal intervention will be safely averted. However, should the state judiciary allow this corrupted clerk-manipulated file to proceed in silence or to file an adverse judgment, applicant will immediately file a formal petition for a writ of mandamus or certiorari to this court. Given the irrefutable digital evidence of record tampering in the file, there is a reasonable probability that 4 justices will grant review to correct a profound structural breakdown of state-level due process. I mean, to me it seems slam dunk, but, who knows. Applicant faces immediate irreparable injury absent an emergency stay. An applicant seeking an emergency stay must demonstrate that irreparable injury will occur during the period the stay is sought. The impending July 24th deadline creates an uncorrectable crisis that satisfies this standard under 2 distinct legal categories. 1, the automatic execution of a void judgment. On July 21st, the administrative machinery below is scheduled to automatically enforce orders built upon the clerk fraud detailed in Section 3A. Under long-standing federal jurisprudence, the execution of a judgment entered in total violation of due process constitutes per se irreparable harm because a void judgment cannot legally vest rights or strip property. The destruction of the status quo. This is the second one. If this court does not freeze the clock, the respondent court will take irreversible administrative actions on July 24th that will completely moot applicants' pending California Supreme Court case and forthcoming Supreme Court writ. An emergency stay is the only mechanism available to preserve this court's jurisdiction to review the underlying structural constitutional breakdown. I got plenty of sleep last night. I'm falling asleep here. No adequate remedy at law. Money damages cannot compensate for or undo a corrupted judicial proceeding managed by fraudulent administrative intervention, because the California Supreme Court cannot realistically clear its docket and rule before the July 24 trap spring and clear its docket and rule before the July 24 trap springs. Applicant has exhausted all local remedies. Oh my God, people. Money damages cannot compensate for or undo a corrupted judicial proceeding managed by fraudulent administrative intervention. Because the California Supreme Court cannot realistically clear its docket and rule before the July 24th Trap Springs, applicant has exhausted all local remedies, leaving this court as the sole shield against an unconstitutional enforcement action. Golly, I'm tired, but it does read, you have to read it a certain way, but I think it's okay. During a hearing, we're going to do facts of the case? Oh, no, we're not. We're only on page 11. Okay, it's fine. I gotta sleep or something. I'm just falling asleep right and left here, you guys. I just read that sentence and like dreamed for about like a split second and had to reread it. So we're gonna come back on facts of the case. It's still gonna be done on July 5th, but I'm just gonna sleep and see what happens. I might go off into July 6th. I want to see what the limit is on a time limit for a YouTube filing, a YouTube post. This might be like 6 hours. I don't care. I don't care. I think I'm going to post everything I did yesterday and today, and it's going to be my introduction to my website. All right, bye. I'll be back in with the bells on, with the jingle bells on. I'm still using this. My washer is broken until tomorrow. They don't work on the weekend. I didn't realize. So we'll be wearing this. I guess I could put on some. It's okay. Bye. Talk to you soon. Bye.